Today we are going to talk about the right to constitutional remedies. Okay, this is the last subtopic on the lecture of our fundamental rights. Okay, so before moving on to that, I will give you some brief intro to this. Uh, it is one of the most fundamental rights as enumerated in Part 3 of the Indian Constitution. The question before the members of the Constituent Assembly was whether the list of fundamental rights should be included in the Constitution. The Indian leaders rejected the British notion of rights. They decided to include fundamental rights in the main part of the Constitution. So, in every document since 1895, the Indians proclaimed that the British view of rights, as enumerated by A.V. Dicey, uh, was not enough for the Indians. They had such an opinion because they feel that the British would ultimately deny the Indians of their rights. They were suspicious of the intentions of British rulers regarding the liberty of the people of India. In 1934, the British Joint Parliament Committee refused to include a list of rights in the 1935 Government of India Act. Uh, Only in 1946, uh, the British government tacitly acknowledged the claim of Indian leaders to include uh, the list of fundamental rights in the body of the Constitution. They held the validity of the Indian view that the list of the fundamental rights be included in the Constitution uh, following the suggestion of the Cabinet Mission Plan. Uh, Thus, Fundamental Rights Subcommittee meet for the first time on 27th February 1947. In the meetings of the members of the subcommittee, it was decided that the fundamental rights should be justiciable and they must be included in the main body of the Constitution. So it becomes possible to protect the individual freedom and individual liberty from any arbitrary action taken by the government. They not only included the fundamental rights in the Constitution, but also try to find out a mechanism of protection of this fundamental rights. They allowed the British device of this prerogative reads uh, like K.N. Munshi, Dr. B.R. Ambedkar, Aladi Krishna Swami Iyer, all strongly and actively favored the inclusion of fundamental rights, sorry, the inclusion of the right to constitutional remedy within the main text of fundamental rights. Uh, Alladi Krishna Swami Iyer suggested that all the high courts and Supreme Court should have the power to issue uh, writs of habeas corpus. It was also said that Parliament should have the power to empower any court in India to issue writs. These writs were treated as the cornerstone of liberty and the freedom for the citizens of India. Uh, the abstract declaration of rights is useless. They are backed by supportive mechanisms to make them effective. The power of the courts to enforce the obedience to the fundamental rights uh, depends not only on the impartiality and independence of the judiciary. Uh, it must also have adequate instruments to act as the protector and the guarantor of fundamental rights. Supreme Court is called the protector and the guardian of fundamental rights of the citizens of India, and it can act against any kind of infringement for the violation of the rights. Article 13 of the Constitution says that any act of the executive or the legislature uh, which takes away or abuses any of these rights shall be void, and the courts are empowered to declare it as void. Uh, Apart from this, the judiciary has been armed with the power to issue writs under Article 32 and the Article 26 for the enforcement of Article 226 for the enforcement of fundamental rights. As per Article 32, the Supreme Court can issue writs. Uh, as per Article 226, high courts are empowered to uh, issue these writs. Article 32 of the Indian Constitution provides for constitutional remedies against violation or transgression of fundamental rights. So now we'll move on to directly the Article 32 that talks about the right to constitutional remedies. So the fundamental rights are the highest importance of the individuals as they are means for the development of the fullest self of citizens of India. Fundamental rights are the basic conditions for the fullest development of personality of all people of India. It is sacred duty of the state to protect those fundamental rights. The reflection of this view can be visualized or seen in Article 32 of the Indian Constitution. Article 32, which is itself a fundamental right, uh, comprises the clause 1, 2, 3, 4. There are the four clauses in this Article 32. So there's clause 1, Article 32, and its clause 1 says that the right to move the Supreme Court by appropriate proceedings for the enforcement of rights which conferred by this part is guaranteed. So you can directly approach to the Supreme Court over the violation or engrossment of your fundamental rights. And now we'll move on to Article 32. It's clause number 2. It says that the Supreme Court shall have the power to issue directions or orders or reads, including uh, the reads in the nature of habeas corpus, mandamus, prohibition, Quo Warranto, and Certiorari, whichever uh, may be appropriate for the uh, enforcement of any of these rights which conferred in the part 3 of the Indian Constitution, that is the fundamental rights. So now we'll talk about Article 32 and its clause 3. It says that without prejudice to the powers conferred on the Supreme Court by the clause 1 and 2 of this Article 32, the Parliament uh, may by law empower any other court to exercise within its local limits or jurisdiction all or any of the power which is exercisable by the Supreme Court under Clause 2. So the jurisdiction of the jurisdiction can be extended by the Parliament. Now we'll talk about this Article 32, Clause number 4. The right guaranteed uh, by this article shall not be suspended except as otherwise provided by the Constitution. So now we'll talk about the B.R. Ambedkar views over or the remarks over the Article 32 of the Indian Constitution. The Article 32, which was referred to as the very soul of the Constitution by Dr. B.R. Ambedkar, provided for constitutional remedy against violation of fundamental rights, which enumerated in Part 3 of the Constitution, Indian Constitution. uh, the citizens are given the right to seek redressal from the Supreme Court in case of transgression of fundamental rights. The Supreme Court is constituted uh, as the protector and guarantor of fundamental rights. The right to constitutional remedy, as I told you, is itself a fundamental right. Beside the Supreme Court, uh, the High Court are also been given a role to protect the fundamental rights. So, under Article 226, High Courts can also issue writs for the protection of fundamental rights, for the enforcement of the rights of the citizen uh, within the jurisdiction of their concerned area. But there is subtle difference. The jurisdiction of Supreme Court and High Court in a matter of issue of the writs are slightly different. So there is a difference between the writs of which issued by the High Court and the Supreme Court. As per Article 32, the Supreme Court can issue writs only in case of infringement of any fundamental rights which enumerated in Part 3 of the Constitution. Uh, Contrarily, uh, the High Court can issue writs. Uh, the same writs can be issued by the High Court not only against the violation of fundamental rights, but also uh, for the enforcement of any ordinary rights which protected by any ordinary law or other legal mechanism. So, in this way, you will find the jurisdiction of High Court is quite limited. It is only within the territory of the state concerned, and whereas the Supreme Court competence is coterminous with the territory of India as a whole. So this is very much clear. The High Court can issue the writs only in his jurisdiction, the area which comes under his jurisdiction. But Supreme Court will issue the writs for the whole India. So here, what is writ? Uh, we'll talk about the writs in case of transgressions of fundamental rights fundamental rights. The Supreme Court or the High Court may issue five writs on almost similar grounds. Both of them can issue the writs. These writs are Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto. So now the first question comes: what are reads? Uh, Reads are orders or directives or the, directions given by the Supreme Court or the High Court, as the case may be, uh, for enforcement of fundamental right uh, or certain ordinary rights. So this is clear to everyone. What are reads? Tell me first.
Yes, sir. Yes.
The PPT is visible to you.
Yes, sir.
Okay. So as I briefed you, what are reads? Reads are the order or directives or directions given by the Supreme Court or High Court, as the case may be, for the enforcement of fundamental rights or certain ordinary rights. So that is by issuing reads, the judiciary of these courts can issue direction stating the quasi administrative authority or judicial or quasi judicial authority uh, to do or not to do certain actions which goes against the very spirit of fundamental rights. So we'll brief you one by one. There's five variants of reads. That is the Habeas Corpus, Mandamus, Prohibition, Certiorari, and others. Quo Warranto. Uh, So first, we'll talk about the read of Habeas Corpus. Uh, what does it mean, basically? So mean it means to have a body. Hence, no man can be detained illegally. Whenever a man is detained, he must be produced before the court within 24 hours. So, if a person has arrested, the police must have to produce them in the court of magistrate within the 24 hours. So, this read is a powerful safeguard against arbitrary arrest and detention. Uh, the underlying principle behind the read of habeas corpus is that a person must gain protection against any sort of arbitrary or unlawful detention. Its main motto was to preserve or to safeguard an individual from unlawful arrest or a detention by the police. So it originated from the English legal system and has been adopted in many countries. Uh, then the second one, there's Mandamus read? What does it mean? It means command. It calls upon a public servant or some quasi public servants to perform some duties. It can be issued reads against the government, also in compliance with the Article 226 and uh, the Article 361, in which it has been stated that a case can be filed against the government for negligence of its duty. So, if the state is not performing the duty, then again, uh, the mandamus is issued against uh, dereliction of duty. The rite of mandamus is an important jurisdictional remedy uh, in which an order is passed on by a superior institution to a supplementary or subordinate court, or uh, the authority to take either a particular form of action or refraining from doing it. This is backed. This is the reason behind that. It is backed by legal rights and reasoning. Uh, so now we'll talk about this prohibition. Uh, it is a writ which is issued by the Supreme Court or High Court. For which purpose? To prohibit lower court uh, from proceeding with a case which is uh, beyond its jurisdiction. Uh, that is to prohibit the inferior courts under them to overstep their jurisdiction if the any subordinate court is going beyond his or her just going beyond the specified jurisdiction, then the Supreme Court and the High Court can issue this writ. Uh, there is a difference between mandamus and prohibition. Uh, Mandamus can be issued against any administrative authority or quasi-administrative authority, but prohibition can be issued only against the judicial or quasi-judicial authority. So this is the difference between uh, the mandamus and prohibition writ. Uh, by issuing the mandamus, the Supreme Court or the High Court give direction for performing certain duties. In the normal scenario, uh, when mandamus is issued from performing certain duties, whereas uh, the prohibition is concerned, it is issued for restraining the lower court from doing anything which is beyond its jurisdiction. So this is a major difference between the mandamus and prohibition. So I explained you the three reads, and the remaining is certiorari and quo warranto. So we'll talk about that. So first we'll talk about certiorari. Uh, it is an important read. It enables a Supreme Court to compel inferior court to submit a record or proceeding to the High Court. Uh, when the prohibition is issued at the initial stage, uh, certiorari is issued at the later stage, but they can be issued on similar ground. Both certiorari and prohibition uh, aims to ensure uh, proper functioning of the lower court and to keep them and to keep the lower courts within the specified jurisdiction limits. Uh, the Supreme Court in Surya Dev Rai versus the Supreme Court in the case of Surya Dev Rai versus Ramchandra Rai and others had explained the meaning, scope, and ambit of the read of certiorari. Uh, the limit of the jurisdiction of the High Court in issuing the read of certiorari was considered by this court in Hari Vishnu Kamath uh, versus uh, Ahmed Issa 1955 case and falling and given four propositions uh, that laid down on the basis of uh, the following verdicts. So we'll brief you about the four that verdicts. Certiorari will be issued for correcting errors of jurisdiction so that the court are refrained from trespassing its jurisdiction or going beyond its limit, so they will not violate their jurisdiction. Second, the certiorari will also be issued when the court or the tribunal acts illegally in the exercise of its undoubted jurisdiction. And when it decides without giving an opportunity to the parties to be heard or violates the principle of natural justice. And the third point, the court issuing a read of certiorari acts in exercise of supervisory role. For an example, it has got a supervisory rule. It cannot exercise in its capacity of being an appellate judiciary. So one consequence of this is that the court will not review findings of fact reached by uh, the inferior courts or by the tribal, not even if these facts are erroneous. The fourth point, an error in a decision or a determination uh, itself may be amenable to the read of certiorari if it is a manifest uh, error apparent on the face of the proceeding. So, for an example, when it is based on the clear ignorance of the provision of law, or I can say it is a patent error which can be corrected by certiorari, but not a mere wrong decision. So these are the limitations say to issuing certiorari. So now we'll talk about the Quo Warranto. The fifth read is Quo Warranto. This literally means by what right. This read is issued uh, to determine the legality of a person's claim to public office. The purpose of this read is to prevent usurpation of a public office by an undesirable or unqualified person. Uh, the read of Quo Warranto is not a petition. It is rather a notice of demand which issued by a demandant to a respondent, uh, claiming that uh, some delegated power is not being vested with the particular person. So it is filed within the court of competent jurisdiction to hold a hearing within 3 to 20 days, uh, depending on the distance of the respondent to the court. Uh, that is a respondent must be present with adequate proof of its authority to execute his or her claim powers within 3 to 20 days. So we'll conclude. There are certain limitations to the right, and we'll talk about the limitations are which enumerated in 33, 34, uh, Article 33, 34. So, uh, Article 33 empower the Parliament to modify application of fundamental rights to armed forces and the police to ensure proper discharge of their duties. So there are certain limitations on this right, and the right to the number one limitation, the right to constitutional remedy under Article 32 may be restricted by imposition of the Article 33, and this Article 33 empowers the Parliament to modify the application of fundamental rights to uh, this armed forces, fundamental rights to armed forces and police to ensure the proper discharge of their duties. So you can find here the Article 32, which stands as Parliament may by law determine to what extent any of these rights conferred in this part shall, in their application to, you can see this on your screen, the armed, the members of the armed forces. The number two is the members of the forces charged with the maintenance of public order. Number C, the persons employed in any bureau or other organization established by the state for the purpose of intelligence or counterintelligence. Or D, or the person employed in or in connection with the telecommunication system or setup process to any force, bureau, organization referred to in clause that you this is that you can read on your screen. That is the clause A to C, which I told you A, B, C regarding to the armed forces and the member of the armed forces and the employed authority in any bureau be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of the discipline among them. So that you can read. That's not a big deal. Uh, so now uh, we'll talk about the next limitation, which is related to this Article 34. You can read the article on the screen. I'm not going to talk about that. I will directly brief it. Uh, Article 34, this is the second limitation on this rights. The under Article 34, during the operational of this martial law in any area, the parliament may uh, indemnify any person uh, in the service of central or state governments for the facts for the acts for maintenance for the acts of maintenance or restoration of law and order. So this is Article 34, and this way it is putting limitations. And the next limitations is related to Article 358, uh, and this 352. Mhm. During emergency proclaimed under the Article 352 of the Constitution, uh, fundamental rights guaranteed to all the citizens of India will remain suspended. Then comes this Article 358, uh, which authorizes the Parliament to restrict the fundamental rights guaranteed by this Article 19 during the proclamation of national emergency under Article 352. Then next comes Article 359. Uh, this is putting the fourth limitation. This Article 359 empowers the President to suspend the right to move the court for the restoration of fundamental rights. Or I can say the Article 359 empowers the President to suspend Article 32 of the Constitution Uh, Such an order is to be submitted to the parliament and is subject to the approval of the parliament by its full strength. Uh, so we'll sum up this lecture here uh, in next 2 3 minutes. The right to constitutional remedy was created as one of the main fundamental rights because the Constitution recognized the need to protect the rights of the citizens. In case, in any of the fundamental rights, any of the citizens being deprived or denied uh, any of the fundamental right, he or she can move to the court for the enforcement of these rights, which enumerated in part 3, that is the fundamental rights. And the court issues reads as the case may be for the enforcement or against the infringement of this infringement of his or her rights. Apart from these reads, there are other mechanisms too, like the National Commission for Minority. It is a flexible, autonomous body created by the government of India for the protection of the rights of the minorities. There is a National Commission for Women which is functioning since 1992 for the protection of the rights of the women. There is National Commission for Scheduled Tribe, which protects the interest of scheduled tribe. The government will monitor and safeguard the rights of the scheduled tribe and offer opportunities in the process of socio-economic development in terms of employment and also in terms of gaining medical or educational relief. Uh, there is also Human Rights Commission in both the central and the states. So these instruments are yet to be developed fully. Uh, the Supreme Court has been assigned a special role as the protector and the guarantor of the fundamental rights by Article 32. Uh, Generally, when the person affected may move to the court for the enforcement of his fundamental rights, but Supreme Court held that any person, even his interest has directly not affected, may move the court. Uh, this is called the expansion of the right to be heard. It favors public interest litigation, PIO. Regarding that, we'll talk about in upcoming units in details this PIO. So, in Gopalan versus State of Madras case, 1950, the Supreme Court took a very narrow approach and view while deciding on as to whether uh, person's detention could be justified on the basis of the procedure established by the law. Uh, the last just last few words. Just make the silence. Ganesh, why are you unmuting yourself? Uh, in 1967, Golaknath case, which I briefed you earlier also, Supreme Court held that fundamental rights are beyond the reach of Parliament. In 1973, in Kesavananda Bharati case, Supreme Court came out with a unique basic structured document. Uh, this basic structured document was never clearly stated. That is, what element exactly falls within the parameter of basic structure is still under veil. It is this basic structure is still a vague issue. But it is very clear that the list of fundamental rights does not fall under in this basic structure document. The Supreme Court held that the Parliament only cannot destroy the basic elements of the features of the fundamental features of the Constitution. Fundamental rights were not included in any of the list of the basic feature. uh, the leaders of the nation must work out hard on the options of the infringement of fundamental rights, so that of this uh, so that of the right of the people, the rights of the citizens are well protected, and democracy of India gets strengthened, and Indian citizens can get a matured democracy. This lecture on this fundamental right is over.